Good morning and welcome to Asm Judiciary for Tuesday, July 7th. We do not yet have a quorum here, but we have enough to start as a subcommittee. So we'll begin with our item number 4, SB 358, Senator Jackson.
Good morning, Mr. Chair, Mr. Vice Chair, and member. I am delighted to be presenting SB 358, which will revise California's Equal Pay Act. I'm so delighted because we have a bill that has broad-based support from everyone from the Chamber of Commerce to the ACLU, and a variety of folks in between, if you note from the analysis. Very excited about the prospect of finally having an effective bill that will give people equal pay for substantially similar work. First off, I'd like to accept the committee's amendments on page 5 of the analysis as author's amendments and thank the committee for its work on making a good bill even better. And with that, in beginning my presentation, I would like to note that California has prohibited gender-based pay discrimination since 1949, and yet we still have an unacceptable gender wage gap. In 2014, the gender gap in California stood at 16 cents on the dollar, so a woman working full-time year-round earned an average of 84 cents to every dollar that a man earned. And this wage gap extends almost across all occupations that report in California, and the gap is far worse for women of color. Indeed, for African American women, it's 64 cents for every dollar a man makes, and for Latinas, it is 44 cents for every dollar that a man makes. Now, while the state's overall wage gap is slightly lower than the national average of 78 cents to the dollar, the persistent disparity in earnings still has a significant impact on the economic security and welfare of millions of working women and their families. The state provisions, which are based on the Federal Equal Pay Act, are rarely utilized because there are so many loopholes that exist, it makes it virtually impossible to establish a successful claim. Pay secrecy also contributes to the gender gap because women cannot challenge pay discrimination if they do not know they are being paid less than their male counterparts. This bill will help close the wage gap in several important ways. First, the employee will no longer face retaliation by her employer for asking about the wages being paid to other employees. You can't challenge what you don't know. Second, this bill would go steps further than current federal law in its powerful combination of additional provisions that would ensure that, 1, women can challenge pay discrimination based on wages paid to other workers at different work sites of the same employer. For example, a grocery checkout clerk who works at a store in West Sacramento could challenge the higher wages being paid to the grocery checkout clerks who are of the opposite sex and working at a grocery chain's Natomas location. Workers, number 2, can challenge pay discrimination based on wages paid to workers doing substantially similar work. For example, a woman housekeeper who provides room cleaning services at a hotel could challenge the higher wages being paid to the male janitor who cleans the lobby and banquet halls. And I suspect we would all agree that the work of a housekeeper working cleaning rooms at a hotel is substantially similar. Some might argue even more strenuous, more difficult, more challenging work than cleaning a banquet hall. Employers would require, 3, that would be required to show that a difference in wages is based on a specific factor that is legitimate, that it serves a business purpose, and is not based on or derived from a gender bias. In other words, it has to be a gender-blind distinction creating that disparity in pay. So, for example, you have a male chef at Denny's who's making more money than a female chef. He works the weekend shifts, and she only works during the week. In this case, Denny's will have to show that the man is being paid more because the weekend shifts are busier and require more cooking than the shifts during the week. The employer will also have to prove that the weekend shift position was open to all chefs, male and female, but the employer hired this male because he was the most skilled, or had the most training, or even that he was the only chef who was willing to work the grueling weekend shifts. Employers would also have to show the factor is job-related and reasonable, and that the non-discriminatory factors relied on account for the entire pay differential. So in the Denny's case, the weekend shift pays more because the job requires more work and is therefore job-related. The employer will have to show that paying the man more for the weekend shift accounts also for the entire pay differential. So with that, I have witnesses here to testify, and I'll let them introduce themselves, and thank you for your consideration. I would ask for your aye vote.
Thank you. Your first witness, please.
Good morning, Mr. Chair and members of the committee. Thank you for this opportunity to share my story with you today. My name is Aileen Rizzo, and I am the mother of 3 daughters and the sole breadwinner of my household. I've worked in math education for over 19 years, and I have 2 master's degrees, one in educational technology and the other one in math education. My professional title is math consultant, and I currently work for the Fresno County Office of Education, which is under the leadership of Jim Jovino. In July 2012, in my 4th year with the county office, one of my colleagues, who had just signed his first contract, shared that he had signed at a salary that would grant him thousands more than I was making, and nearly $20,000 more than I was given on my first contract. This made no sense for 3 important reasons. I had more seniority, more experience, and more education. As the other males shared their salaries, it quickly became apparent that as the only full-time female in the math department, I was the only one who, when hired, was placed as the lowest point of the salary scale. I was humiliated, embarrassed, and ashamed. I appealed to higher administration and even to the newly elected superintendent, Jim Jovino, but all of that came to nothing. With all of my internal efforts exhausted, I felt defeated. My family and I decided to get a lawyer, and I had no idea how long it would take and how much we would invest both emotionally and financially. It took 6 months alone to obtain a right to sue from the Department of Justice, and if we win summary judgment in August, my projected trial date is not until January 2016. My parents sacrificed so that I could be the first to graduate from college. I paid the same tuition as the males around me, yet statistics show that a year out of college in the working arena, women are already making less. Many would say that we do not need more laws, but I am grateful for the laws that we do have. They have given me a voice to at least fight this pay discrimination. No one would prefer the path of a lawsuit. It has taken me literally years to try to get some justice, and I'm not there yet. My employer has deeper pockets and no urgency to resolve this matter at all. Many women like me work years without knowing that the man they're sitting next to is taking more money home to his family. My story is not over. Every day that I go to work and I am asked to do certain job-related skills that I am highly equipped to do, and I am also praised for the work that I have done. I've even received statewide recognition for my work in math education, but all of this really feels tainted because my employer continually chooses to pay me less than my male counterparts, and there is a great realization that I have that I can never recover the wages that I've lost and the retirement that I've lost. I respectfully urge your aye vote.
Thank you. Your next witness, please.
Good morning, Chairman and members of the committee. My name is Jennifer Reich, and I'm the legal director for Equal Rights Advocates. Equal Rights Advocates is a nonprofit civil rights and legal services organization whose mission is to expand and defend access and opportunity to education and employment for women and girls. Over its more than 40-year history, ERA has provided legal representation and assistance to thousands of women from all walks of life, from a variety of industries facing barriers to economic security and equal employment opportunity. Our clients include everyone from janitors and factory workers, farm workers, firefighters, and law professors. Each year, we assist these women to take on the barriers that they're facing to economic security. And we know that one of those barriers is not being paid what they deserve, being denied equal pay for equal work. And as Aileen Rizzo's experience teaches us, this problem is only compounded by the silence that surrounds pay, preventing women from learning about and challenging unequal compensation. We provide assistance to women because we believe in gender equality and because we know that promoting fair pay and eliminating the gap of the wages of women and men in California is more important than ever. Women's earnings are essential to the families, communities, and economy of California. They have played a pivotal role in the economic recovery of the past few years, and they are breadwinners in nearly 2/3 of households with children. However, women in general, and particularly women of color and mothers, lose precious income to a pervasive gender-based wage gap. It affects women in every occupation and industry, and from highly female-dominated fields like nursing to traditionally male-dominated fields like manufacturing and finance. And it touches women of every education and income level, from graduate-educated women like Ms. Rizzo to women with only high school degrees. And despite the federal and state laws on the books, this gap has barely budged in a decade. Senate Bill 358, the Fair Pay Act, which we are proud to co-sponsor, is critical to addressing several of the contributing factors to this gender wage gap. The first is that women still are not always paid equally to men for doing substantially similar work. And the second problem that SB 358 addresses is the widespread lack of information and culture of secrecy surrounding pay that prevents workers from unearthing pay disparities which cannot be explained by any legitimate job-related and non-discriminatory business purpose. SB 358 will strengthen our Equal Pay Act in several respects. It will ensure that workers can point to comparators who are employed by the same employer to do substantially similar work, but may be working in a different facility or office. It will clarify the burdens of proof for both employees and employers under the Equal Pay Act. It will also clarify the factors that employers may rely on to pay employees differently for doing the same work, and require employers to rely on those factors to provide a really specific business justification and demonstrate that that justification accounts for the entire differential in pay. And last but not least, it provides greater protection for workers who want to ask or talk about their pay or the pay of other employees in order to find out whether they or other employees are being paid unequally for doing the same work. These provisions will make a really important and meaningful difference in the lives of real women in this state. By eliminating the outdated same establishment requirement, a woman being paid less than a man who works in the same position at another facility of the same employer will no longer be precluded from challenging that pay disparity. Forcing women to rely on the comparators only from their own work site has led to some absurd results in court, as in one California case where a woman's equal pay claim was dismissed in part because...
We need you to wrap up.
Sure. And in closing, I just want to say that California's equal pay statute is long overdue for amendments, and the adjustments and updates to the equal pay law under this proposed bill will make it clearer, stronger, and more effective. We urge the committee to support the California Fair Pay Act and the working women who do so much to make California's economy strong. Thank you.
Thank you. And I believe we have a quorum. Let's establish the quorum.
Stone.
Here.
Wagner.
Here.
Alejo. Chow. Chu.
Here.
Gallagher. Garcia. Holden. Mainshine.
Here.
O'Donnell.
We do have a quorum. Your next witness, please.
Good morning, Mr. Chair and committee members. Jennifer Brewer on behalf of the California Chamber of Commerce, and we are pleased to support SB 358. We agree that employees who are performing substantially similar duties under similar circumstances should be paid the same compensation regardless of their gender. We believe SB 358 clarifies the standards to achieve this goal and are thankful to the author and the sponsors for working with us so that we can be in a support position. Thank you.
Thank you. Next witness, your name, affiliation, please.
Chris McKaylee on behalf of the Civil Justice Association in support of the measure.
Thank you. Any other witnesses in support? Just give your name, your affiliation, and that you support, please.
Mariko Yoshihara with the California Employment Lawyers Association in support.
Michael Young with the California Labor Federation, also in support.
Dane Hutchings with the California Grocers Association in support.
Shannon Smith Crowley, American Association of University Women in California, in support.
Anyone else in support? Seeing none, is there any opposition? Seeing none, I'll bring it back to the committee. Questions, comments? Mr. Chu?
Just want to say 66 years after the Equal Pay Act was legislated, the fact that we still have women only making 80 cents on the dollar is abysmal. And with that, I want to thank the author for pulling together such a great coalition and working through to develop the consensus that you have. Happy to move the bill forward.
Thank you. So that is a motion. Is there a second? Second. Motion and a second. Any other questions, comments? Senator, thank you for bringing this forward. And with that, the recommended motion is due pass as amended to appropriations. And Senator, if you'd like to close.
Very briefly, I want to thank the Equal Rights Advocates and the California Employment Lawyers Association, who are co-sponsors of the bill. And I want to thank the Chamber, the business community. This is long overdue. I'll just make one point. In a profession like nursing, which is predominantly women, they just did a study. It came out early this year that showed that still the male nurses still make $5,190 a year more than female nurses. The time has come for equal pay, and with that, I would urge your aye vote.
Thank you. Call the roll, please.
Stone?
Aye.
Stone, aye. Wagner?
Aye.
Wagner, aye. Alejo? Chow? Chu?
Aye.
Chu, aye. Gallagher?
Aye.
Gallagher, aye. Garcia? Holden? Mainshine?
Aye.
Mainshine, aye. O'Donnell?
Aye.
O'Donnell, aye.
Your bill is out.
Thank you, Mr. Chair and members.
Thank you. And we do have a proposed consent agenda. Unless someone would like to remove an item from consent, I'll take a motion.
Second.
Motion and a second on consent. Call the roll, please.
Stone?
Aye.
Stone, aye. Wagner? Wagner, aye. Alejo? Chow? Chu?
Aye.
Chu, aye. Gallagher? Gallagher, aye. Garcia? Holden? Mainshine?
Aye.
Mainshine, aye. O'Donnell?
Aye.
O'Donnell, aye.
Those bills are out. That is SB 385 by Senator Hueso and SB 474, Senator Wajkowski. That brings us now to item number 7, SB 589, Senator Block.
Thank you, Mr. Chair. Good to be with you today. SB 589 allows individuals with disabilities who are under conservatorships to register to vote if, with reasonable accommodation, they can communicate their desire to participate in the voting process. Under current law, adults with developmental disabilities who are under conservatorships are routinely disenfranchised at alarming levels. A review of 61 conservatorship cases involving adults with developmental disabilities in Los Angeles County found that close to 90% of the conservatees were disqualified from voting. These disqualifications don't require any specific findings regarding actual incompetency to vote and do not consider any reasonable accommodations that would enable the individual to complete a voter registration card. So basically what the practice has been if you can't fill out a voter registration card without accommodation, if you can't fill it out by yourself, you've been denied the right to vote, an inalienable right, and you've been denied that right in California, contrary, frankly, to what federal law dictates and what the Americans with Disabilities Act dictates, which allows a person to have a reasonable accommodation. So what SB 589 will do, 3 things. Number 1, it creates a presumption that a person has the right to vote regardless of their conservatorship status. Number 2, it protects a conservatee's right to vote unless it's shown by clear and convincing evidence that he or she cannot communicate a desire to participate in the voting process with a reasonable accommodation. And finally, it will align California law with the federal law by stating that people with disabilities are entitled to reasonable accommodations while registering to vote. SB 589 is sponsored by the ACLU, supported by many disability advocates, including Disability Rights California and the Association of Regional Centers, and the Disability Rights Advocates, among many others. There's no opposition for the bill. It's received bipartisan support. In its only other Assembly committee, the only Republican who was there also voted to support the bill. With me here today is Raul Macias of ACLU to testify in support and answer any questions the committee may have. Raul?
Thank you.
Members of the committee, Raul Macias on behalf of the ACLU of California, and we're pleased to sponsor this bill. The ACLU is committed to protecting and expanding our right to vote, and we're also committed to ensuring that people with disabilities are free of discrimination and are valued and integrated members of society. SB 589 would further both of these priorities by ensuring that people under conservatorship aren't stripped of their right to vote without being afforded due process. The U.S. has a long history of practices that prevent people with intellectual or mental health disabilities from participating in the political process by making assumptions about their capabilities. In 2007, in an effort to enhance access to voting and prevent the arbitrary loss of the right to vote, the American Bar Association adopted a series of recommendations for defining and assessing capacity to vote. SB 589 would codify several of those recommendations, as Senator Blanc explained, by aligning California law with the standards recommended by the ABA and with federal law. SB 589 will protect voting rights of conserved individuals, and for these reasons, we urge your aye vote. And thank you.
Thank you. Next witness, please.
Greg DeShare, representing the ARC and United Cerebral Palsy California Collaboration, a coalition of people with intellectual and developmental disabilities and their families, friends, and service providers. When Tom Coleman, the attorney from the Spectrum Institute, which uncovered this problem in L.A., attended last year a training session for attorneys representing people with disabilities in conservatorship hearings. This was a training session conducted by the LA County Superior Court. The question came up, should people with conservatorship be allowed to vote? This question provoked laughter from the attorneys who were supposed to be representing them. The situation with people being denied their right to vote in California because of this is scandalous, and we support the bill.
Thank you. Any other witnesses in support? Seeing none, is there any opposition? Seeing none, I'll bring it back to the committee. Questions, comments? Mr. Wagner? So we have a motion from Mr. Chu and a second from Ms. Garcia.
I don't think I can get there. Let me see if maybe you can solve my dilemma here. It seems the bill allows somebody with, and your phrase, I wrote it down, a desire to participate. Don't we need and shouldn't we expect more than just a desire to participate? There must be an actual ability to participate, not physically. I have no problem with the accommodations, obviously, but the ability to understand the situation, understand the issues, understand they're making decisions not just for themselves. I mean, if they're under conservatorship, aren't they not by definition impaired in some capacity in their abilities to make the kinds of judgments we would like to see from our electorate?
Yeah, thank you for the question. There will always be, in these cases, a court hearing where a judge will determine if the person has the capacity to make a reasoned decision. Frankly, that's a much higher standard than we hold most of our population to when they go into voting booths. Oh, it's true. And this isn't an issue where we're going to be flooding the polls now with people who will change elections. This is a relative handful of people. What's important here is not the number of voters. What's important is the fundamental right of each of these people to have the same rights as a person without a disability to cast their vote.
How many people are we talking about, and would we expect would go into court? And I mean, I know our courts are already overburdened. We all have that problem. Give me an estimate.
I believe when the Spectrum Institute looked at this, they estimated something like 70,000 people, but I'm not certain. And not every single person would have a hearing. They'd be reassessed by a court investigator, and some people won't meet the criteria and won't wind up having a hearing to be reassessed.
Mm-hmm. And is this an assessment that takes place every election cycle, or does it take place only once? So person's health can deteriorate.
Right. I believe people under conservatorship are reassessed every 2 years.
2 years.
Okay. All right. Thank you.
Thank you.
Mr. Gallagher.
I'm having kind of the same concern and problem here. Is that, first of all, we start with the Constitution, which says, that the California Constitution, which says that people who are mentally incompetent shall be disqualified from voting. And at least, in a conservatorship situation, we're at the very least saying that this person is unable to make decisions, and that's why they're being put under the conservatorship in the first place. I get where you're going with this, but I wonder if just having a single criteria where it's just an expressed desire to vote, that is within itself sufficient to show competency. And the key question here is competency. We want people who are competent, mentally competent, to be making voting decisions. Just because you have a desire to vote doesn't necessarily make that finding of competency, which I think is really the key criteria here, right?
Mr. Gallagher, the 2 points on that. One is that desire to vote is if I understand correctly in this bill, the trigger that makes the system look at whether the person has the competency to vote. The other is, I think there's in practice, not perhaps in theory, but the way these conservatorship hearings actually work is there is no real examination of whether the person is competent to vote. Often, the attorney, the ones I was telling you about, who laugh at the idea that a person should be able to vote, will simply waive their client's right to vote, or they will tell the parent, who's normally the one who's bringing the conservatorship action, to check this box, which automatically takes away that person's right to vote. If the conservatorship process worked differently and there were really a thorough examination of whether the person was competent, that would be a different situation. But that's not the way it works.
Yeah, but there's a thorough examination of the competency of the person. I mean, conservatorship it's not a low bar. It's a pretty high bar to get somebody declared under a conservatorship, is it not?
No, it's not. The way the Spectrum Institute in LA found that it actually works is there's a tiny amount of time that the court spends on each one, and often they look at nothing except the fact that the attorney or the parent has checked the right box to remove the person to take away the person's right to vote.
And people under conservatorship can often keep some of their rights and other rights get put in the hands of someone else, of the conservator. So it's not unusual for the court to determine that person can make some decisions for themselves.
Yeah. Well, and then the last concern I have is the potential for abuse. Because people under conservatorship or people that might be in institutionalized care, I think there is the opportunity, especially with vote by mail ballots, for abuse where someone's filling that out for that person, and someone who has competency issues, there is the higher likelihood of them being abused by a third party. So I have some concern there. I mean, is that something you guys have thought about?
Yeah, there are concerns in a lot of our nursing homes and even assisted living facilities. People have others fill out their registrations for them and even fill out their ballots for them, which they then sign. There's always some subject to abuse, but someone as conservative as our colleague, Assemblywoman Shannon Grove, who voted for this in elections, said that this was such a fundamental right that she thought these people with disabilities, if they could prove to a court before a judge that they knew what they were doing and they wanted somebody to do this for them, they should have that right to vote. So I don't always agree with Ms. Grove, but I do on this one.
And Senator, I think for that the process that you've put in place here under the conservatorship is just a de facto denial of the ability to vote. And what you're doing is opening up a process to ask that question based on an individual's desire to vote and a process around that to ensure that there's an appropriate level of competence. And I think the checks and balances that you put in this bill are very, very appropriate. And that's why the recommendation is do pass two appropriations. We do have a motion and second. Further questions or comments? Seeing none, Senator, you may close.
I'll align myself with the comments by the chair for my close. I urge your aye vote.
Thank you. Thank you. Call the roll, please.
Stone?
Aye.
Stone, aye. Wagner? Wagner, no. Alejo? Chow? Chu? Aye. Chu, aye. Gallagher? Garcia? Aye. Garcia, aye. Holden? Mainshine? O'Donnell? Aye. O'Donnell, aye.
You need 2 more votes. We'll put the bill on call.
Thank you, Mr. Chair. Thank you.
Thank you.